Hey, so what happens when you do an accepted for value in a court case? I'll show you what happens. Here's a criminal court case regarding bank fraud. A perfect example of what occurs when you do accepted for value, and you list all that USC 18 USC so and so, and you're the defendant. And you're saying, oh, you have to show me your oath of office before you move forward. This is what happens. Docket 32. Filed using registered mail so-and-so. Nothing wrong with that. Motion for discovery. Conditional acceptance. Motion to dismiss. First of all, a move to dismiss and a move for discovery are two separate tools. According to the rule of proceedings, according to the rule of civic procedures, whether in a state or federal level, the most urgent matter can only be dealt with one at a time. If I was on the other end and I was reading this document and I saw this right here at the beginning, I know that I got you. And then you got this thing called conditional acceptance. Accepted for value under the condition that such and such happens. The concept behind it is fine, but the way people go about using it is where the deficiency is. And I'll show you what happens. It goes on to say, I accept what the plaintiff has offered upon, and by the way, this man is the defendant in this circumstance. I accept what the plaintiff has offered upon first addressing the following issues. It appears there are several errors and omissions that need to be corrected to proceed. Appearing by special appearance, I can only offer a plea of guilty to the fact. This first sentence, it appears that there are several omissions, nothing wrong. And then he went into guilty to the fact. This is what Winston Stroud does. This is what Winston Stroud did in his situation, whereby they went after him for tax. And he was still found guilty nonetheless. If you read the transcript, I'm going to do a video on that, and I'll show the transcript of those court proceedings. If you read that transcript, he did this on paper and during his trial and pre-trial proceedings. And they steamrolled him because none of these are admissible as evidence, and none of these are considered affirmative defense. If you're a defendant and you're doing conditional acceptance, accepting for value, only pleading to guilty to the fact, what difference does that make with an attorney telling you to plead guilty? Whoever has told you pleading guilty to the fact makes you somehow not liable and gives you standing, they have lied to you. Whoever they told you to do this guilty to the fact thing, accepted for value, conditional acceptance, they used it in their situation and they got locked up for it. And this guy almost got locked up for this, but I'll show you how to fix it. He goes, and this is when he went to one of those, whoever it is, to assist him, and they did this for him. I can only offer a plea of guilty to the fact, but innocent of a crime. If only you knew that the fact is what's used to establish the crime. So if you're pleading guilty to the fact and you're saying you're innocent to the crime, you're thinking those the facts are different from the crime. If when in truth, the fact is what creates the crime. So if you're saying you're guilty to the fact, somebody has led you astray. Somebody has taught you wrong. Because you are admitting guilt. The fact is what determines the case. Keep that in mind. The following items are effectively discovery. Okay. Therefore, I can accept this claim and proceed upon proof of claim. See this term, this cliche buzzword, proof of claim? There's nothing wrong with this. But it's just how it's structured, how it's used. The plaintiff, upon proof of claim that the plaintiff can provide admissible evidence and the name of witness who will testify that I am a dissident, as named in the case referring Marcus. See, this argument of all caps is dead. It is dead. It makes no difference in the eyes of the law. Unless you bring in other substantive evidence to show that all caps is different from you and it's dead, then this whole claim that you yourself are making is dead. They're not obligated to do anything. Proof of claim that the plaintiff provided admissible evidence and the name of a witness who would testify that the judge or the prosecutor in this matter are in fact not the liable public trustees and liable sureties for settling and closing the matter, the account, upon my acceptance and directing to them to settle the accounting for this commercial matter. Again, where's the proof it's a commercial matter? And no one is contending otherwise that the judge in this acting capacity, not a public trustee. Now the prosecutor is not, because the prosecutor actually belongs to both ends, in the public and in the private. However they function, whether they're acting as though they're helping you or they're helping the public at large, they belong to a private corporation called a bar, British Accreditation Registry, unequivocally. So right there, whoever's reading this 6th point, know that whoever typed it is clueless. I rebut any presumptions to the contrary based on previous appearance and filing in this claim being trustee defendant as named. I rescind signature and withdraw previous appearance and agreement. Remember, this is supposed to be a discovery, not a separate document. You have to be specific with what you're doing. You cannot mix and match. If you want to create a rescission of signature, an affidavit of rebuttal, do that. Not within discovery. The moment you do this within discovery, you've averted the attention, because now they're going to be looking at this like, okay, you're rebutting it, but you're asking us, what are you really asking us? You want us to respond to this? And then at the end, you're going to say you must respond to the discovery point for point. You're contradicting yourself. And then it goes on, proof of claim that the clerk and other court-related employees do not have a reportable tax liability for the alternative valuation on their carryover basis in this matter. Speculation. This is all speculation right here. Speculation. You have to bring in the evidence that shows that this is viable and that somebody is liable to respond to this. And then it goes, by not providing this evidence, the structure of this sentence makes, by not providing this evidence will stand as evidence that all attorneys, agents, and prosecutors must submit their bond. And see, this is trash. They're not obligated to submit any bond. There's no law saying that they have to. The onus and responsibility is on you to get that and use that to hold them by the balls. And in most states, prosecutors who work for law firms or the state attorney's office are not obligated to get bond. The office is. There's a video that was done on this page regarding voir dire, the caveat, that explains how you can get them to dig into it, or at least it gives a little bit of detail on it. Go watch that. But them individually are not obligated to. The firm that they're doing business through, the division within the county, the prosecuting office, is required per state law to have bond. That is what you ought to be bringing in. And not asking them that, hey, unless you bring that bond in, you can't make a claim upon me. None of that have any standing. And thus disclose their indemnity insurance carrier information to me in the event that I am harmed. That bond they provide shall be further backed by lawful money according to Article 1, Section 10 of the U.S. Constitution. Vague. Lawful money can be Federal Reserve note based on contract. Yeah, gold and silver, but there are other collaterals involved. Go read 4 U.S.C. and 8 U.S.C. regarding obligation of the United States, and you will see that it's not just gold and silver. If you're talking about United States as a corporation and the U.S. Constitution is for that corporation, then you know that there's subsequent things passed along with that to be in harmony with this Article 1, Section 10. And if you're not reading that, that is your problem. Proof of claim that the plaintiff provided me with certified oath of office, bond, and insurance policy claim for information of all bond magistrate, blah, blah, blah. This is the same thing that was mentioned previously, which still has no standing. So now you're repeating things unnecessarily. You're speaking too much. But they did all this accepted for value, a conditional acceptance, proof of claim. Now they're talking about OID. This is a preliminary stage of someone who is vague in their understanding and are just dabbling and just trying to see what's going to work. Whoever assisted this guy create this paper, or if he did this himself, they were either setting him up or he was setting himself up. Then they're talking about fictitious conveyance of language. Fictitious conveyance of language only deal with perjury. When you willingly falsify statement. Read 18 USC 1001. It talks about knowingly and willingly falsifying statement. And if they're not obligated to give you all these IRS tax in the first place because you haven't proven that they're obligated to, then all these USCs that you're listing is dead. I have presented and registered this document vessel in the jurisdiction of Universal Postal Union by paying the transit fee of so and so. Here goes more speculations. Where's the Universal Postal Union law that stipulates these conditions right here? You're not bringing that in. You just speculating. And now you're threatening them. Provided within 5 days. For plaintiff's failure to provide these discovery item proved within the time specified this document on the record would also stand as a motion to dismiss. No, it can't. Discovery and move to dismiss are two separate documents. You're mixing and matching. Automatically, you just annulled your own cause, and they're going to ignore this. And that's exactly what they did. And yet you wonder why they ignore your paperwork. The plaintiff shall also agree to submit the reply rebuttal point for point only using correct sentence structure, parse, grammar, communication for avoid of fictitious consent. There goes the sovereign citizen crap. And then you start listing a bunch of USCs with a bunch of fees. Where's the law that say they're liable to this? How is this contract enforceable? And all this within discovery? This is not how you structure a discovery. So that was document 36. Was it? That was document 32. Now look at the contradictory part here. I'm showing you this so you don't make the same mistake. It says motion to dismiss. Named defendant moves this honorable court to enter an order to dismiss this case with prejudice for failure to provide the discovery. Now this was filed on the same day that supposed discovery was filed. For failure to provide discovery items and proves within the time specified. Plaintiff has stipulated there is no admissible evidence before this court to uphold the plaintiff's initial claim. If you're saying you're putting discovery, then there are rules governing discovery. There's a time period you're supposed to wait to afford them due process. Now, you're not doing things honorably, yet you want to refer to the honorable court to do something for you. You're not affording equity. And this Exhibit A is proof of request of discovery. That is not even a discovery. That was item 32 and 33. Now, guess how the court responded? That was on the 27th of October this year, 2021. On the 19th, guess what the court did? So he demanded the discovery to occur within 5 days, right? Okay. It's been past 5 days now. He put it on the 27th of October. Now it's the 17th. This is how the court responded. A bench warrant. They issued a bench warrant. I repeat. He put in a supposed discovery, making all that threat, talking all that shit, giving them 5 days, not applying parliamentary rules regarding discoveries, talking about conditional acceptance of the proof of claim of you got to give me your bond, your oath, the 1099 OID, you gotta, if you don't do this, 42 USC, 18 USC, and guess how they responded? They realized, oh, you're clueless, don't worry, we got you, you just keep doing that over there. A bench warrant. To any sheriff, deputy sheriff, coroner, constable, or marshal, go snatch his ass up. This is what is going to happen If you're doing accepted for value, conditional acceptance, guilty to the facts and not the crime, you are setting yourself up. Remember the motion to recant, motion to recall? Yeah. Send that to the judge's chamber, send it to the prosecuting attorney, and guess what happens after that? And then show up under the condition that you're going to challenge the constitutionality. After all that trash, now you got to fix it up. Look at this. Order to recall bench warrant. It is the order of this court that the probation warrant issued on the 16th day of November 2021 for the above style defendant is hereby set aside for the following reasons. Defendant appeared in court. That is how you deal with a warrant. Show up. But just don't show up. Especially after you've talked all that shit. They're gonna wrap you up and roast you. Put in the proper documents. That is how you stay in honor. Don't just talk all that trash without knowing what you're doing. Conditional acceptance, all that stuff, it is going to get a warrant issued. But don't worry, there's ways to fix it. So that's just an example. Conditional acceptance, mixing and matching things, not knowing how to really use motions. Of course, I see now why they say motions don't work. I see now why they say we don't do motions, we do affidavits. Of course, because people don't know how to use motions. People are clueless. People are delusional. People are making a fool of themselves. They are using buzzwords like proof of claim, whereby when someone else who actually knows what they're doing come along and they use that same phrase, they set a standard whereby the other parties now think they're comfortable enough to be able to do whatever it is they want with you, with everyone else. When you see someone doing a conditional acceptance, accepted value, telling you to put in a motion to discovery, and then that same paper is a motion to dismiss, and they're listing a bunch of USCs like that, you're going to get a bench warrant issued. But don't worry, there's always a solution. But you better know what you're doing. So no, accepted for value, conditional acceptance is not equivalent to motion to discovery. Don't let people mislead you. Don't let people screw with your life just because it sounds cool. Here's an evidence you just saw. All that conditional acceptance crap, not even knowing how to structure a proper motion, talking all that smack. They issued a warrant. And then he had to come fix it. But it was fixed though. We got it fixed. Again, if you don't know how to deal with a warrant, it's called a motion to recant or a motion to recall under two very simple conditions. Best of luck. Stop following people because it just sounds cool. Then you waste all that sweat equity of yours. You waste your time and effort. When it's time for you to really get things done, you've been dried out. You've been milked. But don't worry. Some problems are easier to fix. Just hope and pray one day you don't do one of these things to the point where it's not fixable. But you can prevent that from happening. Don't just jump into the bandwagon because someone says something that sounds cool.